Hi, I'm Lonnie with Learn Law for All, and welcome today. Today we have José Alfredo Hernández. Welcome, Jose.
Hi, Lonnie. Thank you for having me.
Thank you so much for being here. Jose is going to talk today about removal proceedings. And before we get started, just as a reminder, listening to this podcast does not create an attorney-client relationship with either Jose or myself and any listener. Jose is licensed in California, but does practice in federal courts. I'm licensed only in Arizona. And so keep that in mind. This is for educational and entertainment purposes only and not meant to give specific legal advice to anyone. So again, welcome, Jose. I do have some questions for you. So just so that people know, Jose and I went to law school together. It was really great it was great getting to know you in law school. So I'm so happy that you're doing this and that you stayed in California. I'm a little jealous because it's super hot in Arizona.
It's been wonderful to reconnect. Thank you, Lonnie.
So Jose does immigration and criminal law. And so just did a CLE on the removal proceedings for his immigration law practice and discussed removal proceedings. It's a really great CLE. You should check it out if you have any interest in immigration at all, or if you have any contact with clients that are going through immigration issues. I do have a couple of questions, and let's start with just what are removal proceedings, Jose?
Sure, Lonnie. So in the immigration context, we have administrative proceedings, which are proceedings where an individual is eligible for some type of application, and they basically knock on USCIS's door and try to submit applications for them to be permitted to remain in the United States. In the context of removal proceedings, we're talking about individuals who have been placed in these type of court proceedings. They're administrative court, but they're court proceedings to attempt to remove an individual who is a non-citizen, whether they are undocumented or whether they have been legally admitted, but however they have violated their status in one way or another.
And so how long, what would trigger the removal proceeding?
So there's two basic ways. Oftentimes individuals are found to be here in the US, and you have individuals whose sole violation is to be present without being admitted or present without any type of documentation. Those types of individuals sometimes get referred by the agency, USCIS, when they have submitted an application that does not bear fruit for them. Oftentimes individuals, though, in the more common practice, is individuals get stopped by law enforcement, whether it's the police, the sheriff, or any other type of agency, and they get referred to an immigration judge. So whether they've committed a misdemeanor, a felony, and I'll be honest, here in California, we have petty theft infractions, individuals that have committed an infraction of a certain amount, at a store, they get cited, they get, sent to the criminal courts, and even on a citation, we have had individuals processed by ICE when they put a hold on them, and then they get referred to the immigration court.
Okay, and so once they get referred, that's where sort of the removal proceedings start, right?
Correct.
And so from removal proceeding starting to either being able to stay or being not able to stay, kicked out, how long does that take?
It will depend. So oftentimes those individuals that are not eligible to be released on bond, for example, their proceedings can be as quick as a month and possibly to 6 months. Can they be shorter? Yes. Can they be longer? Yes. But the average amount of time if a person is in custody for removal proceedings is 1 to 6 months. Now, in the context of being out of custody, where an individual is permitted to submit applications and fight their case and fight for their opportunity to remain in the United States, you're looking at anywhere from 6 months to the longest removal proceeding I have ever had has been over 10 years. Now, why is that? An individual could go to the immigration court, right? And the judge could issue a denial, let's say within 2 to 3 years, but the person has an opportunity to appeal. So that decision does not become final if it goes through the appellate process. Now, once you go to the Board of Immigration Appeals, you could go all the way up to the Circuit Court of Appeals. In our case, Ninth Circuit Court of Appeals. So oftentimes those cases get kind of stuck there. And if there's an issue that doesn't resolve but needs to be remanded back, it gets remanded back, and you still don't have those proceedings completed. So it's a little bit tenuous, but if you have a normal removal proceeding where a person is out of custody, we're going to say 2 to 3 years. But as far as how long it could take years.
Wow, that's a long time. But I guess that is, anything you appeal can take a long, long time, and especially when you continue to appeal and appeal and appeal and go up the ladder.
Correct.
So we also talked in the CLE about ways that people could avoid deportation and, things that they could do, like, or get asylum. Is that the better way to say that?
Well,
seek asylum.
Not necessarily. Oftentimes, let's just back up a little bit. In order to seek asylum, okay, you have to have submitted your application within 1 year of having arrived in the United States, okay? So you can file for asylum in 2 ways. You can file for asylum in what's called affirmative application, which is done with U.S. Citizenship and Immigration Service, or you can apply a defensive asylum, where you hear this all the time in the news, where people are coming to the United States, get stopped at the border, get interviewed. They have to conduct what's called a credible fear interview. And if the person is found to be believable, that they actually fear something of returning back to their home country, then they get put into removal proceedings. And it is within removal proceedings context that the person then can apply for asylum. Now, without getting into the weeds of what an asylum request is, you have to basically demonstrate that you're going to be persecuted on account of your race, religion, nationality, political opinion, or because you're a member of a particular social group that your government cannot or will not, protect you from. So it is a very complex area of law. There is a finite group, in my opinion, of people that are actually eligible. Oftentimes you hear a lot of people applying for it, and unfortunately, they're fleeing criminal activity and not necessarily protected, persecution. Does that make sense? So we see that oftentimes in the Mexican community, where they're trying to escape narcos, where they're trying to escape drug lords, right? And the reality is that most of those claims, there is no asylum merit to them, because there's just criminal activity of being, that's being perpetrated on them, right? And their inability of their own government to be able to protect them cannot be the obligation of this country. Now, having said that, we have individuals who work, for example, with the police force in Mexico, and they were being, persecuted by some of these drug lords. Well, they're a government actor, right? And they have no way of escaping that. And then their claim, which would be a much more valid claim for asylum, because they're being persecuted for trying to do their job. Does that make sense?
Right, yeah. Now, we also talked a little bit about domestic violence and removal proceedings, and you had talked a little bit about that. Can you kind of just, give us a little feeler for what that looks like? If somebody's being abused here by a citizen, by their spouse.
So in the US, if you are a victim of domestic violence and the domestic violence is being perpetrated on you or has been perpetrated on you by either your spouse, your parent, or child who is a citizen or a resident, you can submit an application under the Violence Against Women Act. Now, just because it's a Violence Against Women Act does not mean that it's limited to women. The very first VAWA case that I ever had was of a man. So obviously we all are eligible for that. Now, the more common scenario is that an individual is a victim of a crime, oftentimes perpetrated by a person who's not a citizen or a resident or not a relative, right? So there is this a relief called a U visa. And the U visa allows individuals who have been victims of a crime to pursue their opportunity to remain in the United States, as long as they have been helpful in the prosecution of this individual, have been helpful to law enforcement, and they can demonstrate that there was an injury and that the crime that was perpetrated on them is a qualifying crime. Not all crimes qualify.
Well, thank you so much for being here. I appreciate the information. If anybody's interested, we did just record a CLE, and Jose has a lot more information on there. So if you are interested, check that out. Jose, thank you again so much for being here.
Thank you, Lonnie. It's good to be with you.